Welcome back. We're talking about one particular technique of non-literalistic constitutional interpretation, a technique of holistic interpretation, of reading the document as one whole document, of reading between the lines to make sense of the document's largest purposes, to establish justice. And justice is not established when someone can be a judge in his own case, unless the Constitution really very specifically authorizes that in ways that the framers clearly intended. The Constitution talks about protecting the common defense, establishing the common defense. And John Marshall, in a case called McCulloch, says that because a bank is actually a national bank is very useful to, conducive to national defense, it clearly falls within Congress's, the federal government's broad powers, even though there isn't a specific bank clause, because it makes sense, because that congressional power makes sense of the document as a whole. Those were a couple of examples. We're going to talk about some more in this lecture. Let me just step back for a moment, though, and tell you why this vice president not presiding in his own impeachment trial seems to me so interesting theoretically and actually important practically. You might say, well, that's weird. Who cares? Does it matter? Imagine a scenario. This is a very low probability event, but this is how republics actually can end. Imagine a scenario in which a vice president is being impeached. He's corrupt, and he tries to preside at his own impeachment trial and skew the proceedings. In the meantime, while all this is happening, the country is aghast, but who cares? It's just the vice president, they say. And then the president dies. And now this person who should have been convicted becomes president of the United States, and he has no legitimacy in America, in the world. How are people going to respect this corrupt person who, standing on the literal words of the Constitution, has tried to pervert justice? This is how coup d'etat happen, and people rioting in the streets, and how regimes lose their legitimacy. It actually has practical significance, even though it's a low probability event. It has even greater theoretical significance, because you might say, okay, I buy the idea that there are unwritten precepts, like separation of powers, which isn't in so many words, checks and balances, the rule of law, limited government, federalism. Okay, I buy all of that, but where the Constitution is specific, we always follow the specific clause. But here, the specific clauses, when you read them, seem to say the vice president presides at his own impeachment trial. And that can't be right. Here, the Constitution, read holistically, not just means more than the words one by one, sentence by sentence, but the exact opposite of what the words seem to say when read by the standard rules of the English language. So the claim is, sometimes when you read the Constitution holistically, not only do you go beyond the meaning of the sentences, they might, at least in this case, lead to the almost exact opposite result of what literalism would get you. This is kind of the constitutional law equivalent of sawing a lady in half, which is a pretty neat trick if you can pull it off. But my belief is that most lawyers, left, right, and center, would actually agree with me that a vice president can't preside at his own impeachment trial. And most lawyers think that McCulloch versus Maryland is one of the preeminent constitutional cases of all time. And when you read it, it is not a narrow, literalistic, text-based opinion. It's not based on the necessary and proper clause, but on the document as a whole and the idea that it can't specify everything, because if it did, here's Marshall's phrase, it would partake of the prolixity of a legal code. It would be like the tax code. It'd be just too long and complicated and tedious, and an ordinary farmer couldn't have read it. And the great strength of America's Constitution is that ordinary farmers could read it and did read it. It came from the people, and it can't have that populist quality to it if it's really long. It has to be a short document. And if it's short, word by word won't capture the whole thing. We have to read between the lines. We have to read it as a whole. That was also Marshall's thought on the second question that he confronted in McCulloch. The first question was, can Congress create a federal bank? And he said, yes, even though there's no bank clause. There are actually implicit powers, and this one is one of them, because a bank is useful for national security, which is in the document as a whole, read holistically. That was question one. Can Congress create a national bank? Question two is, once Congress is conceded to have power to have lawfully, properly created the national bank, can states impose tax on that national bank? And Marshall said, no, you can't. But here's what he admitted. The statute creating the bank did not explicitly say that no state could impose a tax on it. So for Marshall, what's doing the work in the second part of his opinion, which he strikes down a state law, a Maryland law, imposing a tax on this national bank, what's doing the work is not just the words of the statute in and of themselves. It's a larger structural principle. Once again, Marshall returns to structure, and the basic structural idea is the part can't interfere with the whole. When Maryland imposes a tax on the federal bank, it's basically imposing a tax on all the rest of us outside of Maryland who helped create this bank, and we're not represented in Maryland. When Maryland imposes a tax on the federal bank, the part is controlling the whole, which isn't right. Maryland is, in effect, imposing a tax on New Yorkers and Rhode Island people and people from Connecticut and people from Massachusetts. We all in Congress helped create this bank. We're all funding it. And so when Maryland is taxing it, it's in effect picking our pockets. And that's taxation without representation, because we, as New Yorkers and Connecticut people and Rhode Island people and Massachusetts people, are not represented in Maryland. So a kind of declaration of independence principle. It's not in so many words in the Constitution, but Marshall says the basic structure of the Constitution is people can tax only their own constituents, in effect. And the check on oppressive taxation is if you tax your constituents too much and they think that this is too burdensome, they'll throw the bums out of office. But that doesn't work if Maryland is imposing a tax, the Maryland legislature, not on Marylanders who can vote the bums out of office, but is imposing a tax on New Yorkers and Connecticut people and Massachusetts people when the part is imposing a tax on the whole. Again, structural analysis, trying to make sense of the Constitution as a whole. If Marshall is right, this gives one reason for explaining why federal courts have properly limited states when they sometimes try to do nasty things to other states and limit the ability of other states to sell goods in their markets. This is a doctrine called the Dormant Commerce Clause, and some narrow textualists, Justices Scalia and Thomas, have raised questions about it, but actually the doctrine kind of flows from McCulloch in a way, the deep structural principle that states shouldn't be imposing costs on out-of-staters who aren't represented. Congress can allow individual states to do this. Congress could have allowed Maryland to impose a tax on the federal bank, but that's because in Congress, all are represented. Congress didn't have to create a bank in the first place. It could have created a bank and taxed it. It could have created a bank and taxed it and given that money to Maryland, so it could allow Maryland maybe to do the same thing. But that's because all are represented. The whole is represented in Congress, but not in an individual state. And the doctrine of the Dormant Commerce Clause, another kind of unwritten constitutional principle, is states can't basically interfere with a free flow of goods and services in a national marketplace. But Congress is allowed to do all sorts of regulations and prohibitions because in Congress all are represented. Okay, so that leads to another hypothetical. We're just taking a principle, reading the Constitution as a whole and finding some applications. That's what we're going to do again and again in this part of the course. So here's a hypothetical. If states can't impose restrictions on a national bank, suppose instead they try to impose restrictions. They can't shut down a national bank. What if they try to impose restrictions on, what if they try to shut down a national discourse? So let's imagine it's 1850, and there's this anti-slavery Illinois congressman. Let's call him Lincoln Abraham. He's hypothetical. And he gives a speech against slavery in Congress. He says slavery is a bad thing. We should eventually get rid of it. The federal government should subsidize the abolition of slavery by the individual states because this will be the death of us. It's a very bad thing. And he gives that speech in the House of Congress, and then he goes and says that, and he prints it up as a pamphlet, and he distributes that pamphlet to his friends in Illinois, and he also, through private channels, gives it to friends to distribute in North Carolina and other states. And then North Carolina tries to prosecute Lincoln Abraham for stirring up slaves, which is a crime in North Carolina. In fact, it's a capital offense in North Carolina to criticize slavery. And they try to shut down preachers in the pulpit who say slavery is a sin, it's a bad thing. So North Carolina tries to do this in our hypothetical. Now, can they do it? And you might say, well, of course they can't. We have the First Amendment. But the words of the First Amendment, actually, what's the first word of the First Amendment if we're just literalists? The first word of the First Amendment is Congress. Congress shall make no law abridging free speech and freedom of the press. But in our hypothetical, it's a state that's doing it. So can a state shut down this discourse on slavery, the biggest political, legal, constitutional issue in the nation in the 1850s? Can a state shut down that national discourse any more than it's allowed to shut down a national bank, which it's not allowed to do? So if it's not allowed to do that, should it be allowed to shut down a national debate? But if it isn't, where does the Constitution say so? Well, you might say, actually, there is a free speech clause. Now, today, we have a thing called the 14th Amendment that says, no state shall make or enforce any law which will abridge the privileges or immunities of citizens of the United States. No state can violate fundamental freedoms, and one of those freedoms is free speech. And we're going to talk a lot about that clause and how that's definitely a clause about protecting free speech against states like North Carolina when they try to shut down free speech. But there's one problem for a hypothetical Lincoln Abraham. Have you figured it out? The problem is the 14th Amendment hasn't yet been adopted. We're talking about 1850. The 14th Amendment is after the Civil War. And because states like North Carolina did try to shut down free speech, we needed a 14th Amendment that said we're going to protect free speech, not just against Congress, but against states. But that's off in the future. And the words of the First Amendment only talk about Congress. So what could Lincoln Abraham do? Well, maybe he could point to a clause of the Constitution, the original Constitution, before the 14th Amendment, that says there should be freedom of speech and debate in Congress. And indeed, in Congress you can get up and say anything you want, and that freedom of speech and debate can't be challenged outside of Congress. You can't be prosecuted by a state court, in a state court, or sued for libel in the state court, or prosecuted by the president. So there is absolute freedom of speech and debate under the original Constitution in a congressional assembly. Only problem is Lincoln Abraham didn't just speak in Congress, he distributed the pamphlet. And maybe you could say if the only thing he distributed is this pamphlet that's word for word his congressional speech, well, maybe he'd be protected by the Article I speech and debate clause. But suppose he went beyond what he said on the floor of Congress. Or, just to modify the hypothetical, suppose Lincoln Abraham isn't a sitting congressperson, but a candidate for Congress. Suppose he's just a speaker. And he thinks that slavery is wrong and the federal government should work to get rid of it, and so should states. And again, he's being prosecuted in North Carolina. And now he doesn't have speech or debate clause immunity, either because he's a congressman who went beyond what he said on the floor of the House, or because he's not a congressman at all. And now we come to the deepest thing. The deepest idea is forget the First Amendment. It only says Congress. Forget freedom of speech and debate, which is only about congressmen. Forget the 14th Amendment, which isn't on the books yet. We, the people of the United States, are sovereign. Governments work for us. We don't work for them. They are our servants. They can't tell us politically what to do, what to say, what to think. We get to govern ourselves. In England, Parliament is sovereign, and they have freedom of speech and debate. In fact, the word Parliament, from the French parler, to speak, that's a special speech spot, and Congress is a special speech spot, and state legislatures are special speech spots. But in America, the whole country is actually a speech spot that deserves a lot of protection, because in America, we get to vote, and we can't vote unless we can talk about public issues amongst ourselves. And it's an idea of making sense of the Constitution as a whole. We have free and fair elections, and in those elections won't be free and fair if incumbents are allowed to shut down challengers, if our government servants are allowed to tell us what to do and think and say. It'd be as if my butler, my valet at my dinner table tried to tell me I couldn't talk to my guests about something. No, he works for me, not the other way around. That's a structural principle. It's reading between the lines. It's reading the Constitution as a whole, and I think it gives our hypothetical Lincoln-Abraham very broad freedom of speech, not maybe the same kind of absolute freedom of speech he has on the floor of the House, because on the floor of the House, he can actually spew lies, and you can even maliciously, intentionally, and he can't be sued for libel. He's utterly immune when he's on the floor of the House. There's a special, absolute kind of free speech that he has on the floor of the House. But outside that floor, it's not that he has no free speech, but he has just the free speech of all Americans, which is a very broad one. Yes, that free speech is limited by rules that you can't intentionally spew lies with malice, but you have an absolute right to express your political opinions, and no one can shut that down. That's a basic American free speech principle that flows from understanding the system of the document as a whole, a system based on popular sovereignty and the idea that the elections are supposed to be free and fair, and our government servants work for us, not the other way around, so we get to criticize them, what they do, and government policy. That's a structural argument. And it's an argument broader than the First Amendment. It's giving us rights not just against the president, as the First Amendment does, but against federal courts, against, not just against, Congress, as the First Amendment protects against Congress, but against presidents, against federal courts, against states, against counties. It's a broader principle than the language of the First Amendment itself. Okay, one other hypothetical, and then we'll conclude by talking about this picture. What about Let's talk about the real Abraham Lincoln, not Lincoln Abraham, but the real flesh and blood Abraham Lincoln. Suppose in mid-March of 1861, North Carolina trumps up charges against him. They have, and instead of seceding, they say, we are going to indict Abraham Lincoln because we say that he was in cahoots with John Brown and killed a lot of people because he was plotting the Harper's Ferry massacre. And it's all trumped up. But they say, we demand that Abraham Lincoln come down and face justice here in North Carolina. Can a state prosecute a sitting president? Now, you see, the Constitution doesn't say in so many words that they can't. There's no explicit clause that says that they can't. But if they could do that, you'd have the part controlling the whole in violation of the McCulloch principle that if the federal government creates a bank, one individual state can't undo it. They could basically undo a national election. And you might say, well, actually the Constitution does say that they can't do that because the Constitution says presidents can be impeached. And only impeachment, that's the only court to judge a sitting president. But textually, the document doesn't say that. And vice presidents can be impeached. And let me say, it's very clear that vice presidents can be sort of prosecuted in ordinary criminal courts. Aaron Burr killed Alexander Hamilton at Weehawken, and states actually initiated prosecutions against him. Spiro Agnew, Nixon's first vice president, actually was a crook, and he was prosecuted while a vice president then stepped down, but he wasn't immune from prosecution. Federal judges can be impeached. Federal cabinet officers can be impeached. But that fact alone doesn't mean that they're immune from ordinary state criminal prosecutions when they're in office. So the impeachment clauses don't say that this is the only mechanism and you can't have ordinary prosecution. And that's not the rule for every other impeachable officer, vice presidents, judges, cabinet officers. They can all be criminally prosecuted. So it's not a textual argument quite. I can read it into the words, the executive power of the United States shall be vested in the president, but the words don't clearly compel that reading. What's doing the work is a structural principle. And the structural principle is the state, apart, shouldn't be able to undo the whole. That we have national elections, and the president actually has to be accountable to all of us. And when he is, he might be doing things that are deeply unpopular, doing the people's business as a whole. Internationally, domestically, he might do stuff that makes him deeply unpopular in some state or county or town. And precisely because of the Constitution structures a grand inquest in which he's accountable to the nation when he misbehaves. It's in the Senate of the United States, all are represented, all the states. And so because he's a national figure, he has to be judged by a national tribunal. And the text doesn't say that specifically. It's implicit in the whole. Now, once he's out of office, ordinary states can have Adam. That's fine. But they shouldn't be allowed to undo an election. Now, you could say, oh, well, Professor, I buy all that, but it's just the words executive power that are doing the work. But states have governors in whom executive power is vested under state constitutions, and most sitting governors actually can be prosecuted. And here's why. Sitting governors don't handle wars and foreign affairs the way presidents do, and it's a much bigger problem if a state's able to distract a president when he's in the middle of a foreign crisis or a war or something like that. When a state prosecutes its own governor, you don't have the part undoing the whole the way you do structurally when the state tries to prosecute a sitting president. And when the federal government tries to prosecute a sitting governor, Rod Blagojevich or something like that, again, it's not the part undoing the whole, it's the whole monitoring the part. So governors and presidents are both vested with executive power, but governors aren't immune, sitting governors, from criminal prosecution. Presidents are, because within the federal system, they're the head of the federal justice system, and everyone else is inferior to them and can't prosecute them unless they give them the go-ahead. And states shouldn't be allowed to undo national elections. The part shouldn't be able to undo the whole. A structural argument. And that structural argument, by the way, has been endorsed by scholars on the left, Charles Black, for example, on the right, Robert Bork, Ken Starr. It's pretty broadly accepted, but the Constitution doesn't say so in so many words. We have to read between the lines. We have to make sense of the document as a whole. No man can be properly a party in his own case. No part may properly judge the whole. These principles that no man can properly judge his own case and no part can properly judge the whole, these help the document as a whole make sense. They are ways of reading between the lines in the Constitution, and this is one of many techniques, not the only one, by which we go beyond the written Constitution, but ultimately in order to vindicate the written Constitution. Before I conclude, just a word or two about this picture. This is the first presidential impeachment trial. This is the impeachment trial of Andrew Johnson. And he's being judged by politicos who, many of whom might want to be president. That's what the definition of a senator is, someone who wants to be president, it seems. And the guy who's presiding over the trial, the Chief Justice, himself actually wants to be president. Solomon P. Chase had run for president in 1860, come in third in the Republican primary. He had tried to knock Lincoln off the ticket. He was a cabinet officer for Lincoln, Treasury Secretary. He had tried to knock Lincoln off the ticket in 64 and make himself president. In 1868, he wants to be president yet again. He wants Andrew Johnson's job. And he's not alone. Chief Justices in American history have often been presidential contenders. John Jay and John Rutledge, actually, who were early Chief Justices, had come in third and fourth, respectively, in the presidential election of 1789, right after Washington and Adams. William Howard Taft is going to be Chief Justice. He's a former President of the United States. Charles Evans Hughes is another Chief Justice. He had actually run for the presidency. He stepped down from the court to run for the presidency. Earl Warren, a Chief Justice, had actually run for vice president if Dewey had defeated Truman. Remember that famous Chicago Tribune ad mistakenly predicting Dewey defeats Truman? But if Dewey had defeated Truman in 1948, Earl Warren would have been vice president. So Chief Justices are often people, pretty large people with presidential ambitions. Chase was one of them. But merely having presidential ambitions doesn't mean that he had to recuse himself. Because built into the very structure of the Constitution, very plainly, is politicos. People often with presidential ambitions are going to be judging other politicos. That's okay. But that's different than the vice president presiding over the impeachment trial of the president. Because the vice president would automatically become president upon a guilty verdict. That's too much of a conflict of interest. A vice president presiding over his own impeachment trial, that's too much of a conflict of interest. Here, if the president's going to be convicted, it doesn't mean that Chase becomes president. It means that, he's going to be able to run for it like everyone else, and he'll get it only if the American people vote for him. And that's not too big a conflict of interest. You say, well, that's a really, that's a fine line you're drawing, Professor. I agree. And constitutional law often involves fine lines. But here's the fundamental point, and here we conclude. Allowing senators to judge presidents, even though senators are politically ambitious, presidentially ambitious politicos, allowing them to try a president, allowing the Chief Justice to preside, the Constitution clearly builds those sorts of things into the documents. That's ambition, checking ambition. That's the main object of the law, and we go with it, because that's what the people bought into. Vice president presiding his own impeachment trial, no one thought of that. No one thought that was going to happen. That just is a weird, absurd, peripheral application with a bigger conflict of interest, and that wasn't a central feature, the main object of the Constitution as understood by we, the people of the United States, when we ordained and established it. Okay, so that's one technique. It's the technique of holistic reading. It's not the only technique. We've got 11 chapters to go. So more techniques to discuss, so stay tuned.